Welcome to This Explainer. Today we're diving into a genuinely fascinating and complex web, the international and national laws surrounding ship arrests. Think about the fundamental challenge of maritime law for a second. Ships are massive, incredibly valuable assets, but they're also peripatetic, meaning they're constantly wandering from port to port, crossing international borders every single day. Trillions of dollars of global trade rely entirely on these rules functioning properly. So if a ship owner defaults on a massive debt, how do you legally secure that floating asset before it simply sails away into a completely different jurisdiction? Well, that's exactly what we're going to unpack today. All right, here's our roadmap for today. We'll be covering the global arrest framework, common law jurisdictional approaches, civil law jurisdictional approaches, India's statutory legal framework, Indian judicial interpretations, and finally, the future of ship arrests. Let's get right into it. Section 1. The Global Arrest Framework, focusing on international conventions. To kick things off, let's establish exactly what a ship arrest actually is. Think of it as the ultimate legal net. It's a formal legal step where a vessel is detained by court order to secure a maritime claim. We're talking about things like unpaid crew wages, salvage costs, or damage caused by the ship itself. Because of that peripatetic, wandering nature of ships we just mentioned, this mechanism is highly time-sensitive. If a claimant doesn't arrest the vessel while it's sitting in a friendly port, that ship could easily sail into international waters or some complex, uncooperative jurisdiction. And if that happens, the claimant might forever lose their chance to collect what they're owed. Globally, there are two primary international treaties that attempt to govern this high-stakes process. First, you have the foundational 1952 Brussels Convention. This established a specific list of maritime claims that actually justify an arrest. Crucially, it allowed for the arrest of sister ships, meaning if the primary offending ship is somehow unavailable, you can legally target an associated vessel owned by the exact same entity. Pretty powerful, right? Then, decades later, came the 1999 Arrest Convention, which was designed as a modern upgrade. It expanded the list of claims to include modern concerns like environmental damage and ship sale disputes. More importantly, it really attempted to bridge a massive gap between civil law systems, which historically permitted arrests for practically any claim against an owner, and common law systems, which restricted arrests strictly to specific maritime claims. But here is a pretty wild reality check on international maritime law. 77 countries currently enforce the older 1952 Convention. Meanwhile, the modernized 1999 Convention has a mere 17 ratifications. Why such a stark contrast? Well, major maritime powerhouses like the UK and the US completely refused to ratify the 1999 treaty. This severely limits its global impact and reflects a strong preference by these heavyweight nations to just rely on their own domestic laws rather than some overarching international rulebook. Which brings us to Section 2, Common Law Jurisdictional Approaches, with a focus on case law. There is a deep, fascinating contrast in how common law giants handle ship arrests. The United Kingdom governs this via the Senior Courts Act 1981, which actually directly implements the 1952 Convention into its own domestic law. The UK Admiralty Court handles what are called in rem actions. In rem literally translates to against the thing, meaning the lawsuit is filed directly against the physical property of the ship itself, not the owner. Now, over in the United States, they aren't a party to either of those international conventions. The US relies purely on its own federal laws, primarily CMLA. And the US uses this incredible concept called the personification theory. This legal fiction literally treats the vessel itself as a living, breathing legal entity. The ship itself is considered the wrongdoer and is independently liable for claims, completely separate from its human owners. Looking closely at UK case law, it showcases a really stringent procedural rigor. For example, way back in 1851, the landmark case the Bold Buccleuch established a powerful rule. A maritime lien attaches to the vessel itself and travels with it secretly. So claims like salvage and crew wages are fully enforceable even if the ship is completely sold to an innocent new owner. Decades later, the Indian Grace in 1993 clarified the human element, stating that the shipowner actually becomes a full party to the proceedings the very moment the Admiralty Court steps in. And cases like the Chaska-Mollin in 1997 reinforced that an arrest absolutely must give rise to a real maritime lien or statutory right. You can't just casually arrest a massive commercial ship on a whim. You need ironclad legal footing. Across the Atlantic, U.S. courts have their own delicate balancing act between claimant rights and owner protections. As early as 1868, the China recognized that a ship could be arrested just for supplies furnished directly to it. But to prevent the abuse of this immense power, cases like Amstar Corp in 1979 really strictified the rules. A claimant must possess an actual, recognized maritime lion to arrest a ship under U.S. rules. A standard breach of contract just won't cut it. And to fiercely protect owners from malicious competitors, Coastal Barge Corp in 1990 set a very high bar. If you wrongfully arrest a ship in the U.S., you are only liable for the owner's resulting financial damages if they can definitively prove you acted in bad faith or with gross negligence. All right, Section 3, Civil Law Jurisdictional Approaches, looking at codified systems. In civil law systems, the written code completely dominates. France, for instance, incorporated the 1952 Convention into its Code of Transports, but allows for a remarkably broad application. In France, ship arrests are actually possible for claims against charterers, the people who are simply renting the ship, as long as a maritime lien exists. Germany also incorporated the 1952 Convention into its commercial code, but they take a radically different approach to liability compared to common law. Remember how the U.S. requires proof of bad faith for a wrongful arrest? Not in Germany. They impose strict liability. If you wrongfully arrest a ship in Germany and disrupt their business, your underlying intentions simply do not matter. You are financially on the hook for the damages, period. But even though codes dominate, French case law highlights some immense procedural flexibility. In the 1984 case Navire Spartan, the court allowed a ship arrest based on a lien, even though the underlying claim wasn't actually against the legal owner of the ship. This illustrates a fascinating divergence. Civil law systems can sometimes offer a much broader, more flexible net for claimants trying to secure their money than common law systems do, provided the initial written code allows for that broad interpretation. Which brings us to Section 4, India's statutory legal framework, what we like to call the hybrid net. India sits in a really fascinating position because it hasn't ratified either the 1952 or the 1999 international conventions. Instead, it created a highly sophisticated hybrid net through its Domestic Admiralty Act of 2017, consolidating a bunch of confusing colonial-era laws into a single modern framework. It meticulously lays out the rules. Section 4.1 explicitly lists 23 distinct maritime claims that justify an arrest, covering everything from title disputes to salvage, crew wages, and environmental damage. Section 5.1 grants high courts the power to order an arrest for security. Section 10 dictates exactly who gets paid first, and Section 11 actively protects ship owners by demanding claimants provide an unconditional undertaking to pay damages in case the court later decides the arrest was totally unjustified. So when a ship is arrested and subsequently sold, who actually gets their money first? Well, Section 9 of the Indian Act lays out a strict hierarchy, and it specifically prioritizes the most vulnerable human elements of shipping. At the absolute top are unpaid crew wages, repatriation costs, and social insurance, and this specific lien legally survives for up to 2 full years. Just below the crew comes loss of life or personal injury claims, followed by salvage services, port dues, and finally general tort claims. It's a system fundamentally designed to protect human welfare way before general commercial interests. Let's look at Section 5, Indian Judicial Interpretations, and how they are adopting global norms. Because India hasn't formally ratified those international treaties, Indian courts have pragmatically stepped in to weave global standards directly into domestic law. Back in 1993, the Supreme Court in the M.V. Elizabeth case took a massive step, declaring that High Court Admiralty jurisdiction inherently incorporates civil law, common law, and equity to seamlessly align with global norms. Most remarkably, in the MVC Success case, the Supreme Court actually applied principles directly from the 1999 Arrest Convention, effectively filling the gaps even though India isn't a signatory. Furthermore, cases like MV Nordlake showcase the court's immense discretion. Courts can actually balance the scales by allowing vessels to be released upon the deposit of security that is less than the full, potentially inflated claim amount. This ensures strict procedural fairness so shipowners aren't held hostage by overly aggressive claimants. Let's look at exactly how this plays out in the real world with a quick step-by-step scenario. Imagine a Singapore-based company, let's call them AB Fuels, supplies $500,000 worth of bunker fuel to a ship named MV2000 in Mumbai. The owner defaults. AB Fuels then discovers a ship is currently docked in Chennai. Under India's framework, AB Fuels immediately files a suit in the Madras High Court under Section 411 for material supplied to a vessel. The court quickly verifies the invoices and contracts and, boom, issues a formal arrest warrant. NV2000 is legally detained in Chennai. That ship literally cannot leave until the owner provides a $500,000 bank guarantee, or, if they just abandon it, the ship is auctioned off within 45 days under Section 11 to finally pay the debt. That is the Indian legal net in action. Finally, Section 6, the future of shipperists. Charting new waters. Stepping back to look globally, we are dealing with a system fraught with critical trade-offs. Common law systems like the UK and US offer high adaptability. Their courts can innovatively stretch precedents to address wildly new scenarios. However, this heavy reliance on shifting judicial interpretation creates a lot of anxiety and uncertainty for international shipping companies who really crave predictable rules. On the flip side, civil law systems like France and Germany offer immense stability and clarity because the rules are strictly codified in black and white. But those rigid written codes completely lack the agility needed to quickly adapt to modern, emerging issues. Think digital shipping contracts or fully automated vessels. Both systems possess critical flaws. Ultimately, a ship arrest is an absolutely essential tool to secure maritime claims, ensuring that massive debts don't simply sail away into the sunset. But its global execution remains incredibly tricky. With the 1952 convention really showing its age, the 1999 convention lacking major adoption, and hybrid systems like India's patching things together domestically, we have to ask, should the international community push harder to universally adopt the 1999 convention, or has modern maritime trade evolved so much that it's time to draft an entirely new universal treaty that brilliantly combines the adaptability of common law with the clarity of civil law? That is the big question charting the future of these waters. Thank you so much for joining me for this explainer. I hope this really helped you untangle the complex global net of ship arrest laws.